Okay, good afternoon or good morning or good whenever it is to you. My name's Matt Weidner. I'm an attorney. I practice foreclosure defense and consumer law in Tampa, Florida. Now, I'm coming to you today to talk about an academic article that I've written along with a colleague of mine, Michael Fuino. Now, Michael's a fantastic young attorney who works in the office with me, and he and the other young attorneys really have helped to develop an area of law which had remained inconsistent and frankly too stable for a long time. I give these younger attorneys a lot of credit for developing issues by frankly just not taking things at face value, but digging a lot deeper into what's happening in an area of law that had remained far too untouched for far too long. This academic journal, this law review article that we've written is entitled Foreclosing in a Hurricane, the Disturbing State of Foreclosure Law in Florida. This article that we're talking about, it's a call to action for lawyers, to judges, to the general public to become more aware of the complex issues that we find in foreclosure cases all across not just this state of Florida, but all across the country. So some of the key questions that we'll seek to answer in this video today are the key problems in foreclosure. What is it that's driving the fact that our courts are clogged up with foreclosures and that more foreclosures are being filed? There's several who's and several questions that we have to ask. We want to know who's driving the litigation, who's making the settlement decisions, who wins or loses at the end of the case, and who can a court sanction for engaging in improper conduct, and finally, what are the hidden forces that are driving the foreclosure chaos? These are questions that haven't been fully investigated at the trial court level. We're only now starting to see them be investigated at the appellate court level, and only now is the general public waking up to the fact that there are many complex questions that are brought to the surface with foreclosure. I think we're all getting far more accustomed to the fact that foreclosure is not just about a homeowner that hasn't paid a mortgage. There are many complex factors involved here, including all these dark and shadowy forces behind the scenes that impact settlement decisions, that impact who files foreclosure, that impact whether a case is going to get settled or not, or whether a homeowner is going to get a modification, or whether a short sale will be impacted. So the purpose of this law review article was to get to the heart of many of these questions and frankly address one of the most important topics in all of foreclosure, which is who is it that's behind the scenes here? In our legal parlance, we ask the question, who has standing, or who is the party involved in this litigation that's really making the decisions? One important point that I want to touch on in this video is the fact that consumer activists and attorneys who have been in this space of public defense, who have taken the challenge to stand up and defend our court system and defend the rule of law, have found themselves the targets of investigations and abuse and persecutions. I can speak personally to the abuse and persecutions that an attorney and an activist suffers because he or she dares to stand up and challenge the status quo. We have to keep in mind that the battles we're fighting here pit us against the most powerful forces in this nation right now. The banks, the institutions, and in fact our own government, who's doing their part to support, defend, and in fact encourage the banks and institutions who've run roughshod all across this country. I'm going to point to a couple of articles here that make this point very dramatically. You'll see a newspaper article here from the Palm Beach Post that talks about disciplinary, or in fact lack of disciplinary action taken against those folks on the other side of this foreclosure battle. I would also draw particular attention to the battles that have been faced by Lynn Sismoniak, a friend of ours in this battle, who did a whole lot to bring to the surface the fraud, the other abuses that consumers have been suffering, and in fact, the fraud and abuses that our court systems have been victimized by the banks and institutions. Now, Lynn is a fantastic figure, a champion for consumers in the rule of law. And some public officials, elected public officials in states other than Florida, have taken up her charge and taken up the information that she shared with the officials in this state. But it's important to note that even though Lynn Sismoniak worked tirelessly along with our friend Lisa Epstein to bring issues of fraud and improper documents to the attention of our court system, she found herself a target of criticism by the Office of Inspector General here in the state of Florida, and in fact the Attorney General's office. If you look at the link here that deals with Lynn Sismoniak and Lisa Epstein, it's the report from the Florida Office of Inspector General, who was tasked with reviewing the firing of two attorneys working in the Attorney General's office. And in this article, if you read the report from the Office of Inspector General, you'd think that Lynn Sismoniak and Lisa are kind of out there making improper claims. an important thing to keep in mind is that Lynn Sismoniak, who reported all of this information to the federal government, it's reported that she will collect up to $18 million as part of the whistleblower settlement. So a powerful figure for the state of Florida, Lynn Sismoniak, who did her part to report to the government what was going wrong in our court systems, was rebuked by our own state here in Florida, but then has become a national celebrity, if you will, and in fact widely recognized by the federal government for pointing out the very abuses that she got criticized for in the state of Florida. Finally, the two attorneys who worked very closely with consumers all across the state of Florida to investigate their claims of improper practices by the banks, June Edwards and Teresa Clarkson, who were attorneys actually with the Florida Attorney General's office, were summarily dismissed by the Attorney General's office under very quite questionable circumstances. So the point to be made from all of this is that the attorneys and the activists who've been standing up to defend the rights of the public and the rule of law and to support our court system have found themselves on the other side of the court system. And this is something we all need to keep in mind in this space of consumer defense. So the fact of the matter is, the foreclosure crisis as we've come to know it in this country is really a disturbing commentary on the breakdown of the American political experience, and it shows that our court system has not kept up with the problems that the banking industry and the Wall Street corporations have dumped into our court system. So I say it and I make it clear. The foreclosure crisis represents a failure of the American political experiment. It's not fair to criticize the banks and the institutions in Wall Street for their role in the foreclosure crisis and the breakdown that it represents of the American political experience. We all have to take responsibility for the failure of this country and what foreclosure represents, because we all sat aside and watched the banks and institutions and watched Wall Street destroy this country. And as the foreclosure crisis plays out in our courts all across this country, we've all sat aside and watched it happen. It's time for us all to get involved and take a far more active role in what's happening in our court system in particular and in the larger political environment. We've got to take responsibility for this crisis and do something about it before it's too late. The fact of the matter is that what foreclosure shows us is our nation's entire political system has become hopelessly corrupt. Wall Street, the corporations and industries sacrifice the greater good of the nation over short-term profits. Our state's underfunded court system failed to meet the challenge to protect our nation from harm, and the existing mainstream media has failed to fulfill their function to protect, inform, and educate the American people. Now, there are two key documents that I'm going to be relying on here as part of this discussion, and you'll see the links right down here. The first one is the draft of the law review article, Foreclosing in a Hurricane, that I worked on with this young lawyer in my office. The draft's right there, and at some point in time I'll change this and put the final version so you can find the link to the Stetson Law Review article that's going to be published. I give a lot of credit to the legal community here in the Tampa Bay region, in particular Stetson University, for taking on this incredible, complex task of telling the foreclosure story through law review and through the appellate court cases. The second document that I'll be relying on to a lesser extent is another document I put together called the Compendium of Capacity Cases. Now, I'm going to do a longer video on this document later, but for now it's enough just to say that it's there and then refer to it. It contains a very interesting mix of cases that are important all across the country, but particular focus, of course, on foreclosure cases in Florida. Now, the two documents that I just mentioned right there are important because they get to the heart of what is the key issue in foreclosure cases, and that is who has the right to foreclose. We all understand now that we're dealing with shadowy plaintiffs. We're dealing with corporations and entities that we can't identify easily or clearly. In many cases, we're not dealing with the bank or an institution that we had any formal relationship with. They just pop up and happen to be suing us. Now, for the longest time, it was very clear who it was that had the right to foreclose on a property in Florida. In fact, the Supreme Court, in their Rule 1.944, makes it clear, and they state, and I quote, "It requires the plaintiff to allege that it both holds and owns the mortgage in question." That's the key word. The rules of the Florida Supreme Court require the plaintiff to plead that they both own and hold the note in question. But trial courts and, frankly, appellate courts all across the state have gotten far away from that very explicit and very clear directive from the Supreme Court. They've mixed together the terms own and hold, and they no longer have been holding the plaintiffs to the requirement included in the form and in the rule that the plaintiff both own and hold the note in question. Now, folks, here's a key point that I want you to understand about foreclosure and why it is that it's so important that we understand who in the world it is that's foreclosing. You have to understand that in courtrooms all across this country, judges are quite literally giving away America to institutions, to entities, to corporations that they do not know and cannot identify. This is frankly a matter of national security. What happens in a foreclosure case is you are granting title to someone other than the rightfully vested owner. It's important to understand that in a foreclosure case, what you are doing is you are taking away the ownership, you are ripping away the title to property, and you're giving it to that plaintiff. You're giving it to another party. Now, this is why I talk about the fact that this is a national security issue. I cannot understand how it is that judges across this country are content to sit in courtrooms and sign judgments that give away a little piece of America every time to entities they cannot identify. I've asked this question repeatedly in courtrooms, and that is, Judge, do you know who it is that you're granting this property to? Because do you understand that when you sign that foreclosure judgment, you're giving away a piece of America to a company, to a corporation, to a trust that you cannot identify? We have to understand that there are dark and shadowy forces that are coursing throughout the financial system, and we're finding that in our courtrooms. These dark and shadowy forces are the trusts, are the plaintiffs that are changing their names, are the other entities that are driving the decisions about when a foreclosure is filed, whether a modification is offered, whether a sale goes through, whether that homeowner gets to stay in their home. Now, I have the opportunity to work in one of the best jurisdictions in this country, here in Pinellas County, the 6th Circuit of Florida, thoughtful judges that understand their role and responsibility, that take their constitutional oath very seriously, and frankly are quite concerned about what's happening in their neighborhoods. We have to understand that here in the state of Florida, our judges are elected, and I know our judges here in this area in particular take their oath quite seriously, and take their responsibilities to their neighbors seriously, and take their oath of responsibility to the Constitution very directly. Now, I've stated it previously, and I mean it very seriously. The judges that operate in our courtrooms do an extraordinary job in the vast majority of circumstances in fulfilling their constitutional responsibilities. The fact of the matter is that it's not the judges, for the most part, that have failed the people, that have failed to do their job. It's us. It's the citizens of this country, and particularly the citizens in this state, who failed to do our job to protect the Constitution, to defend our court system, and to protect our rule of law. Now, it's true that our court systems have been inundated by the banks and institutions. The banks and institutions have taken hold of our court system like an ooze, like a fungus, like a virus. They've attacked our court system. They've invaded that space, which is our public space. So part of the call to action that comes in this video is for you and you and you and every one of you to occupy our courtrooms. I want a resurgence of that American patriotism, that American ethic, that American responsibility that says to you that you have a responsibility to get inside your courtroom and understand what happens there. I want an Occupy the Courtroom movement to occur. Occupy the Courtroom means that you as a citizen will take an active role in understanding the very real challenges that our courtrooms face. There is a constitutional right, deeply rooted in the history of this country, that we have a right to be inside our courtrooms. And frankly, with every right there comes responsibilities. Every American citizen has an absolute responsibility to understand they have a right to be inside courtrooms, to watch what's going on, to understand what's going on. But part of that responsibility of going inside courtrooms is to make sure you understand the rules and you follow them. When you go into our courtrooms, you have to understand that our judges and their staff and the clerks and the sheriffs that are in there are working under an incredible pressure. Now, the biggest part of this message here is I want citizens, I want voters, I darn sure want attorneys to understand the pressures that our courts are laboring under, and I want you to come away from this experience of occupying the courtrooms being a powerful advocate and a passionate advocate for our court system. Because frankly, we're entering into desperate times here, folks. We're entering into some of the most tumultuous times this country might ever face. We need our court system more than ever before. We need our elected judges to be there standing up for Americans, standing up for the basic values and rights that this country stands for, and defending the Constitution. We need you as citizens to be in there on the ground every single day in courtrooms supporting what our judges and their staff are doing. Now, there's a key point that needs to be made right here, especially in the state of Florida. Florida's entire circuit court system is funded with less than 1% of the entire state budget. Courts receive just 0.07% of Florida's current $70 billion budget. The bulk of this goes to trial courts, which are vital to public safety, economic prosperity, and the peaceful resolution of disputes. This is a key point here, why I think it's so important This is a key point, and this is why I think it's so important that people understand the critical function of our court system, the peaceful resolution of disputes. The fact of the matter is that our courts are struggling like never before because the legislature is not properly funding them, because the executive branch is not properly respecting them, and because we as citizens are not getting out there and defending the job that our judges and our court system does. So an important second element of the point that I just made, the fact that Florida's court system is funded by less than 1% of the entire state court budget, is found in a case called Crist versus Irvin. Former Governor Charlie Crist filed a case that was in the Florida Supreme Court, Crist versus Irvin. This was a key decision because it got to this issue of our courts being underfunded. And one of the key lines and key takeaways from this decision was the point that the Florida Supreme Court found that our courts were operationally underfunded. Now, they came just shy of that key word, constitutionally underfunded, but I frankly think that if the Florida Supreme Court viewed the same case today, given the current funding constraints that our courts operate under, they would find that we are, in fact, living in a state that has a court which is constitutionally underfunded. The key point we all need to understand is that when our court system is not properly funded, society starts to break down. Our court system is the basis for a stable and peaceful society, and that's why every one of us have an absolute obligation to get inside our courtrooms and understand exactly what's happening in there and support our courtrooms. I practice in 6th Circuit, Pinellas County, and I got to tell you, in all my time in our courtrooms, I'm continually impressed with what I see as a proper and effectively functioning judicial system. Particularly in foreclosure space, you see consumers in there not represented by an attorney, but that does not prevent a judge from giving them the same amount of respect that they would even an attorney that's been practicing for 20 or 30 years. It really is a great testament to the judges that operate, particularly in this area here on the west coast of Florida, that when consumers go into courtrooms, when they're operating under the same rules that attorneys operate under, they're treated with as much deference and respect as attorneys are. It's a key takeaway that consumers have a right to be in courtrooms, and especially here in the 6th Judicial Circuit of Florida, consumers are granted an incredible amount of respect and deference by our judges. And I think it's important that we show our judges an equal amount, or frankly a greater amount of respect based on that. Okay, so we're all aware now that we're in the middle of a foreclosure crisis, but the fact of the matter is that this has been a long, slow crisis that's much like a hurricane, and that's sort of where the title for this law review article in this presentation comes from, Foreclosing in a Hurricane. Now, up on the screen right now, you'll see a link to the Florida Task Force on Residential Mortgage Foreclosures, and the link is right there. Now, it's important to note that this report was released in 2009. The Florida Supreme Court, recognizing that we had a catastrophe of monumental proportion bearing down on the state of Florida, gathered together with judges and consumer activists and attorneys and began to study what was coming down with foreclosures. The report, which was released in 2009, the task force predicted a crisis in Florida's courts, and they were dead right. The only problem is they failed to appreciate just how big a mess we were in and how much worse it's gotten and how much worse it's going to continue to get. Now, there were two important things that came from the Florida Supreme Court's Task Force on Residential Mortgage Foreclosure. The first was the Supreme Court found that the plaintiffs and institutions had not been doing a proper job at investigating claims in their complaints. I could be more direct and specific about what they found and what was going on in our courtrooms, but suffice it to say, the Supreme Court found that there were problems with the way plaintiffs were proceeding with foreclosure cases. So they passed a rule which mandated the plaintiffs engage in a good faith effort to verify the information contained within the complaints. So the first thing that came out of the report was the verified complaint rule. The second thing was mediation. The Florida Supreme Court gave consumers of the state of Florida two important rights. Number one, the plaintiffs were required to verify their complaints, and number two, homeowners were entitled to foreclosure mediation. Now here's the problem. Even though the Florida Supreme Court mandated and directed that the plaintiffs in these cases were supposed to engage in a good faith effort and verify the information in the complaints they were filing, the banks just decided to ignore all of that. And secondarily, with the mediation, they just decided that they weren't going to participate in good faith in mediation. Probably the most direct repudiation of the Supreme Court rules came from a high-profile law office that was operating in the state of Florida. The law office is David Stern. I'm going to read right now a quote that comes from a prospectus filed with the Securities and Exchange Commission from the law offices of David Stern. It says, the Supreme Court has recently taken steps to ensure that proper documentation is filed in foreclosure actions. And if DJS does not comply with these new rules and procedures, the foreclosure actions on which they're working may be dismissed, which may result in DJS receiving fewer referrals and, since they are our primary client, reduced revenues for us. However, DJS may not be successful in complying with these new rules. When I read that quote right there, it blew me out of the water. How can anybody say that the Supreme Court has passed rules, but we may not be able to follow it? We may not comply with those rules. Even here, the plaintiffs recognize that there may be consequences for not complying with the rule. I'm disappointed to say that even years after this began, where complaints were supposed to be verified, there have been hardly any consequences at all. The plaintiffs, even after the rule was enacted, continued to file complaints and didn't comply with the rule. And even as late as today, they continue to play games with this rule. One of the most frustrating things about this entire process is even though the Florida Supreme Court gave rights to citizens and requirements on the lawyers practicing before that you were supposed to verify complaints, even as late as today, 2012, we continue to have problems and games being played with the verification of complaints. Now, here's a link to an appeal that I have pending right now in the 2nd District Court of Appeals. The plaintiffs still are playing games with this verified complaint rule. I'm hoping that the 2nd District Court of Appeals will issue a very clear ruling here, and that ruling must be simple. We all must follow the rules of the Florida Supreme Court. Now, I mentioned that there were two things that came out of the Florida Supreme Court's Residential Task Force on Mortgage Foreclosure, and the first was the verified complaint rule, roundly ignored by the plaintiffs on the other side, ignored for years with impunity, and continuing even to this day, games still being played with the rules issued by the Florida Supreme Court is very disappointing. But even more disappointing was the fact that our Florida Supreme Court directed that all plaintiffs that engaged in foreclosure of residential properties would provide the defendants in foreclosure cases the opportunity to sit across the table with their clients and mediate foreclosure disputes. Now, mediation has been extraordinarily successful in all of civil litigation, from family law cases to professional sports. Mediation and arbitration has proven to be an extraordinarily effective way of resolving disputes. However, it hasn't worked in the space of foreclosure, and why is that? Well, I believe the truth of the matter is mediation in foreclosure has not been particularly effective because you cannot negotiate with terrorists. And so we have these financial terrorists on the other side of the table that are not mediating effectively, are not coming to the table and negotiating in good faith with the defendants. We should keep in mind, folks, that the defendants in foreclosure cases are the very American taxpayer that bailed out these banks and institutions, and then the banks and institutions are failing to work with them. Even though the banks and institutions were successful in killing mediation, the right to mediation, here in the 6th Judicial Circuit, our court system has instituted a very fair mediation process. Our judges have made it clear that it's important, if you're going to try and throw a citizen of Pinellas County out into the street, you're going to sit across the table with them and negotiate in good faith. I'm confident that what we're going to find here in Pinellas County is that when the banks and institutions are still required to sit across the table with the homeowner and do so in good faith, they'll work out solutions that make sense for everybody. One of the key points in this article, Foreclosing in a Hurricane, was understanding the concept of standing. And the foreclosure concept, it quite simply is who has the right to foreclose against a homeowner and throw them into the street. The questions that flow from this issue of standing is who owns the note, who's directing the litigation, who filed the lawsuit, who should the homeowner be negotiating with? If the homeowner wants a modification, who has the ability to issue a modification? If the homeowner is trying to do a short sale, who has the power or the authority to grant that short sale? A key issue in foreclosure is that the ownership of these notes and mortgages that are being foreclosed on is being hidden behind nominal plaintiffs. It's being hidden in the shell game of the nominal plaintiff and who they are. There are servicers that are acting on behalf of undisclosed principals, and I'm telling you right now that this is a problem. We should never allow in our court system agents to be acting on behalf of undisclosed principals. We need to require the plaintiffs to show who it is that they're foreclosing on behalf of. We cannot be allowing plaintiffs to take property all across this country and to file lawsuits against our citizens without disclosing who it is that they're foreclosing on behalf of. So the big lie that exists in most foreclosure cases is the fact that the plaintiff that's suing the homeowner does not own the note, does not have any ownership interest in that note. They're suing on behalf of undisclosed principals. We have agents in courtrooms that are suing on behalf of undisclosed principals, and this is a major problem. I had a gut-wrenching loss in a trial here not too long ago, and a key point that I raised in that case was the fact that the plaintiff that was in a courtroom was suing on behalf of an undisclosed principal, and I wanted some proof, some evidence, some shred of evidence about who they were suing on behalf of. Now, most disturbing, the day after the particular case that I lost went to sale, the 4th District Court of Appeals issued an opinion that we'll talk about in just a minute here, which, if it had been released prior to the sale, I believe would have prevented this from going through. We're going to be appealing that, and I'll talk about that later, but this emphasizes the fact that this shifting plaintiff name, the hiding behind names and foreclosing on behalf of undisclosed principals, is improper, and our appellate courts are starting to recognize that. So another one of the big lies that exists in the foreclosure space is a phrase that's often repeated, and that is that the mortgage follows the note. It's an old case called Johns versus Gilead. It's in fact a 1938 case from the Florida Supreme Court. And it's often used to support the proposition that any old plaintiff can walk into court with a promissory note without any representation about who owns it or who owns the mortgage or anything else, wave around that original promissory note, and throw an American citizen out into the street. Now, Johns versus Gilead is an ancient case, Florida Supreme Court, 1938, and it exists in a factual scenario that is worlds apart from what happens in foreclosure cases today. So I find the reliance on Johns versus Gilead in this modern day context to be particularly disturbing. Our courts need to understand that relying on this case that existed prior to the advent of the Uniform Commercial Code and the detailed rules that exist in foreclosure is completely inappropriate. I call this lie the lie of negotiability. The lie of negotiability is repeated in courtrooms again and again and again. And you'll see this link right down here. I linked to some of the arguments that are perpetrated in support of this gross misrepresentation of the law. These mortgage notes were never intended to be negotiable instruments. They were always intended to be assigned via an assignment of mortgage, and yet that's not what happens. We have plaintiffs wandering around, waving around notes, and it's causing chaos throughout our court system. More importantly, it's causing chaos in the title insurance industry and the title systems that record who it is that actually owns property. Now, I want to recognize that long ago, long before this foreclosure crisis spilled out all around this world, there was a judge here in Pinellas County that got it, that warned the world that what we were going to be experiencing here in 2012 was worse than anything we'd ever felt before. Judge Walt Logan, back in 2004, issued an opinion in a case called Mers versus Aziz. Judge Logan looked at what was happening in his courtroom with these nominal plaintiffs hiding behind other names and said, this is going to be a problem. He dismissed these cases because he wanted to know who actually owned these things. I said it often, and I'll say it again. If the world had listened to Walt Logan in Mers versus Aziz, we would not be having nearly the problems we experience today all across this country. So in this law review article, I try to track the history of standing and ownership and plaintiff and who has the right to foreclose. And there's a key case in there called Williams Specialty. Williams Specialty stands for the proposition that if you don't have standing on the date that you file the lawsuit, it was improper for you to file the lawsuit and the case gets dismissed. Now, the fact of the matter is this phenomenon, this scourge of fraudulent and improper documents that have been filed in courtrooms all across this country is forever going to be a black eye on our court system. And that could have been prevented had we paid more attention to cases like Aziz and Williams Specialty. And one of the outgrowths of Williams Specialty and the cases that come from that is to say that assignments matter and that the documents that are filed on our public records are important. But what's happened after Williams Specialty and in the recent history is even though we have documents, thousands, tens of thousands of assignments of mortgage that are filed in our public records, our formally sacred documents, our formally sacred public records, we have plaintiffs and institutions claiming that those documents don't matter anymore, that you should just ignore assignments of mortgage and other documents. What this represents is the fact that when industries are allowed to go wild and out of control, chaos reigns. And in this document that I'm describing right here that's been filed, there are examples of what goes wrong and the consequences for documents which are improper. These are the kind of things that courts need to be focused on in order to rein back in these industries that have gotten wild and out of control. Now look, the whole robo-signing controversy is real and it's significant. Correctly or not, I'm credited with coining the term robo-signing. The link that's here takes you directly to the Wall Street Journal article where they did some investigation of where this term robo-signing began. And again, correctly or not, I'm partially credited at least with coining that term robo-signing. When the term robo-signing first hit our lexicon, we understood that this represented a desecration of our court process and court records. But in the years that have passed since robo-signing became part of our general conversation, the banks and institutions have tried to convince us that it really doesn't matter, that we should just ignore all those documents. But I'm here to tell you now that when you file things in a courtroom, that should mean something, and we shouldn't just ignore this concept of robo-signing. Robo-signing is a euphemism for fraud or forgery or disrespecting our court system, and this nation cannot stand if we're going to allow things like that to happen on a regular basis. Now, there have been a lot of people in this country that have taken robo-signing seriously, and people all across this country might remember when Lynn Sismoniak was on 60 Minutes talking about robo-signing and looking at the good work that Lynn and Lisa Epstein and others have done in documenting the robo-signing. Lynn Sismoniak and Lisa have been recognized by property recorders and officials all across this country, including Jeff Thigpen in North Carolina, and John O'Brien, also a property recorder, who've taken the information quite seriously that Lynn Sismoniak brought to their attention. I think it was John O'Brien that commented that his office was a crime scene and he wanted somebody to do something about it. There's a real call to action here, folks, and that is for property recorders all across this country to recognize the sacred oath that they took to protect the sacred records. I want to put a special plug in here for our friend Lisa Epstein. You'll see a link to her website right here. Lisa is running to become the clerk of court in Palm Beach County. Lisa's been a passionate advocate for consumer rights and the rule of law all across this country. I encourage you to look at her website there and support her candidacy. Okay, so there are 5 cases that cause us all to really scratch our head because they represent that something really wrong has gone on in this country and in our court system. Those cases are Riggs, Glarum, Harvey, Taylor versus Deutsche Bank, and Pino. Now, I'm going to have links to each one of those cases on there, but I'm going to go through each one of them. Now, Riggs was a case that was down in the 4th District Court of Appeals, and it dealt with the fact that a note that was endorsed wasn't endorsed. And the thing that's so important about Riggs and some of these other cases that I'm talking about is the appellate court first issued an opinion which was supportive of consumer rights, but then on rehearing, the decision was flipped on its head, turned 180 degrees. I'll give a link here to the Riggs case. It's a quite curious situation here. And again, it's a case where at first we had a case that appeared to support consumer rights and the rule of law, and on rehearing, the case was flipped backwards and turned on its head. The second case is Glarum versus LaSalle. Now, this is a case where, again, we had a decision that came out of the 4th District Court of Appeals that appeared to support, or didn't appear to support, there's a decision that came out of the 4th District Court of Appeals that supported consumer rights and was powerful for consumers. But in a most bizarre circumstance, the plaintiffs filed for rehearing on this case and called it the calamitous confusion of Glarum, that somehow, because of the court ordering that plaintiffs should be held to the same standard of business records, if this decision were allowed to stand, it would cause calamitous confusion in courts all across this country. In fact, that was never going to be the case. But in a most disturbing turn of events, the 4th District Court of Appeals reversed Glarum, or in fact issued a rehearing in Glarum that watered down much of the initial findings in there. A case that I was intimately involved with, and in fact a case I argued in the 5th District Court of Appeals, was Taylor versus Deutsche Bank. This case had a disastrous effect because it restated law in a most curious way. It asserted for the first time a proposition that MERS, the Mortgage Electronic Registration System, could in fact take possession and transfer notes. Now, MERS never has taken the position that it had any interest in notes and that it could transfer or do anything. So for the first time, Taylor versus Deutsche Bank took the position that MERS could transfer notes when in fact that was never argued at the trial court. That was never argued at the appellate court. This was just a decision that came out that was in fact quite curious. Okay, so the next case I want to talk about is this Harvey versus Deutsche Bank. Now, this is an extraordinary case here. Here's a woman that was sued in foreclosure, Jacqueline Harvey. She loses that case and appeals to the 4th District Court of Appeals. Now, the 4th District Court of Appeals issued an opinion which frankly wasn't favorable. And I got to tell you, when I first read about it and read that a pro se had filed this appeal, I thought to myself, well, that was a poor showing for a pro se person to file an appeal. And frankly, we should be very careful with appellate work because any appellate court cases that are filed have the possibility of coming up with a bad outcome. And in fact, that's what happened in the Harvey case. But I got to tell you, when I finally read those briefs that were drafted by Jacqueline Harvey, I was quite impressed. She did a masterful job of citing the issues very clearly and pointing it up very clearly for the court. So here's a pro se person that filed an appeal and did a really good job. Again, an opinion came out of the 4th District Court of Appeals. she filed a rehearing on that decision, and when the 4th District Court of Appeals came out with that second opinion, it slammed it even harder. So be careful what you ask for in rehearing is the message that came out of that Harvey case. But, and I give this Jacqueline Harvey a heck of a lot of credit, even after the 4th District Court of Appeals slammed her, both at the original opinion, then in the rehearing, she didn't take no for an answer. So she's filed again in the Florida Supreme Court, asking the Florida Supreme Court to reverse the decision made by the 4th District Court of Appeals. And I really give her a lot of credit for that and hope that the Supreme Court will listen to that. Speaking of the Florida Supreme Court, I want to talk about another case that's critical for courts all across this country, and that's called Pino versus Bank of New York. Now, Roman Pino was foreclosed against on a property down in Palm Beach, but our friends over at ICE Legal defended them, and that case was ultimately dismissed. Well, because there were allegations of document irregularities in that case, Pino wanted to continue pursuit of that case. The 4th District Court of Appeals found that they couldn't proceed with that case. But now, and what is a key quote that we all need to pay attention to, the 4th District Court of Appeals said, and I quote, many mortgage foreclosures appear tainted with suspect documents. I didn't say those words. The 4th District Court of Appeals did. And the question that they submitted to the Florida Supreme Court in the Pino appeal was, what should we do when we find that many foreclosures appear tainted with suspect documents? I'll speak very plainly and clearly. Here's what the appellate court should do. Here's what the trial court should do. When you are faced with suspect documents, the case must be dismissed, and the parties that are responsible for providing improper documents to the court should be sanctioned. Let me make it clear. Here's what should happen. When a court encounters improper documents, the parties that submitted those documents should be sanctioned and the case should be dismissed. That's the answer that should come from the Pino appeal that's currently pending before the Florida Supreme Court. I've put a link here to the pleadings that are filed in this Pino case, and they really are quite extraordinary. Just look at this quote right here. It comes from an amicus brief filed by the banking industry. It says, the banks seek to avoid unnecessary harm to their already distressed industry by encouraging fair but efficient means for foreclosures to proceed in Florida. The instant case, however, has the potential to do real harm by imposing undue impediments to the foreclosure process. Ladies and gentlemen, this is a quote that comes directly from a pleading filed in the Florida Supreme Court where the banking industry is asking the Supreme Court to relieve them of problems that they caused themselves by filing false and improper documents in courtrooms all across this country. The Supreme Court should not let it stand. I find this document so extraordinary. The members rely on the stability and consistency of Florida law in order to advance foreclosure proceedings efficiently and fairly. Yeah. And we, as citizens of the state of Florida, rely on our court system to enforce the rules and the laws of the court. We cannot have banks and institutions, or any parties for that matter, engaging in improper court practices. And what this brief seeks to do is to excuse them of this conduct. The second part of this, it says, if the members face potential revocation of voluntary dismissals, lending practices in Florida could come to a halt. This is a key point out of this brief right here. What the banking industry is saying is that if the banking industry is held accountable for the improper practices that they engaged in our court system, lending should grind to a halt. This is financial terrorism because they are threatening our court system that if they're held accountable for following the laws, lending will grind to a halt. I find that inexcusable, and I frankly find it repugnant that a banking industry would file in the Florida Supreme Court something which alleges improper conduct. They go on to say, and I quote, the threat of sanctions would force lenders either to prosecute technically infirm cases rather than cure defects in new proceeding, or risk being prohibited from refiling after faulty documents have been corrected. Such unduly harsh procedural impediments would deprive lenders of the ability to collect their loans or apply collateral to satisfy these obligations. Ladies and gentlemen, the banks and the industries failed to follow the law, and now they want the Florida Supreme Court to sanction their improper conduct. We must not allow this to continue. We must insist that the Florida Supreme Court hold the banks and industries accountable for the crimes that they've committed and the wrongdoing that they've done in this court system. Okay, so here's a quote from this petition filed in the Florida Supreme Court that really makes my head want to explode. Read this right here. Moreover, scrutiny of the validity of an assignment of mortgage may be inappropriate under any circumstances. One more time. Scrutiny of the validity of an assignment of mortgage may be inappropriate under any circumstances. The banking industry has filed a pleading in the Florida Supreme Court, and in that pleading, they assert that it may be inappropriate for anyone to investigate the validity of that document. That's just insanity for the banking industry to say to the Florida Supreme Court that no one has a right to investigate or inquire as to the impropriety of the documents that they filed in courtrooms all across the state. Ladies and gentlemen, that's anarchy. That's lawlessness. The Florida Supreme Court should not encourage such behavior, and we're hoping, frankly, that a decision comes out of the Florida Supreme Court which provides appropriate sanction and guidelines for courts all across the state. Okay, so we began this video with a discussion of a law review article that's going to be published here in the next couple months. Then we got into some of the appellate cases that have been issued and dealt with some of the appellate cases that are currently pending. The one thing that I want to focus on right here is a decision that was just released out of the 4th District Court of Appeals. You've got a link right there. It's called Elston versus CW Capital. Now, I talked about the fact at the beginning of this video that our courts need to insist on proper description of who these parties are. Now, Elston versus CW Capital stands for a very important proposition, and that is that banks and institutions have to properly identify themselves when they file foreclosures in this state. We shouldn't rely on representations that are not supported by fact, which would permit banks and institutions to throw people out into the street without proper evidence. Now, I recently lost a trial. It was gut-wrenching, the defeat. And it was a key point in this trial was this issue. Plaintiffs should be forced to identify who it is that they're working on behalf of. We've got an appeal pending. We'll have some of that information posted up on here. But as part of this academic discussion, I want people to understand that this is a rapidly evolving area of law. We need to be focused on this. This concept of standing and real party and interest ties into many key concepts. Who it is that has the right to foreclose, and in fact, who it is that's taking back property all across America. The consumers, the voters, the taxpayers, we bailed these banks and institutions out. They're continuing to shove billions of dollars of our money in their pocket, and they're doing it improperly. We need to insist on proper legal procedures, and we need our judges to stand up for Americans and do the right thing in these foreclosure proceedings. Okay, so the point of this video was a detailed survey of all the appellate cases dealing with foreclosure defense in the state of Florida. I hope at the end of it you'll understand this is a complex issue that requires sophisticated lawyering by good attorneys who are passionate about their job and who understand the court system and passionate about the rule of law.